It's Brian Problem Parker here. That's me, causing problems for bad guys and debt collectors. And great stuff for you. So today's, again, as I always say, there's a uniqueness to this very regular lawsuit today. We're going to take a look at a JPMorgan Chase lawsuit, and it's a defense that is based on three things: securitization, the ID theft that my client had to go through, and of course, they turned themselves into debt collectors way before the lawsuit was filed, but it's confirmed with their mini Miranda usage. So the uniqueness of this fact scenario has the defense rich in instructions for you. As always, remember to love, like, and subscribe, and we'll keep bringing the good stuff. As you know, my great membership website, if you choose to self-represent for a very low price at collectionstoppersolutions.com, over 260 videos, hundreds, if not thousands, of Word templates. You just apply your law and your state's facts. And let's rock and roll. Top things to do today. Let's put them up. There we go. Review the lawsuit that you receive and identify the linchpin. Remember my linchpin videos? I think I got at least 2. There they are. Swish. Identify your defense. It's usually based on 2 things: your linchpin assessment, and you already know it going in before you even get the lawsuit, what the defense you have. In this case, there's a combination of ID theft, and the securitization of it will come with the lawsuit. But there's always a defense, in my experience. So mostly it will be tearing the lawsuit apart that you receive. Use their documents against them. In this case, Stenger & Stenger is the law firm. They traditionally, over many states, will file a fill-in-the-blanks lawsuit. It's the same every day. I sit in my sleep with no documents attached. Well, they do that so you can't hold their feet to the fire, but that also has horrible consequences for them, as you will see. You have to create your counter affidavit for your answer and your affirmative defenses that you rely upon. Again, see all my videos on account stated statute videos, creating counter affidavits, like tons of them. Free PDF, how to create a counter affidavit. Okay, enough said. Here's the fact scenario. Client comes to me saying, I have a Chase card with JPMorgan, and since around March of 2022, when I discovered that some obscure country setting, just stuff that's totally not mine, I have on my credit card statement. So I found that, and in March, I contacted JPMorgan. They said, don't worry about it. We'll get on top of this. You're protected. You're a card member. And so they did just that, and it wasn't any good. They kept stringing her along. She kept checking in. They kept saying it's under investigation. So eventually, she just waited it out, checked in with them, and they kept saying, it's disputed, don't worry about it. She disputed with the credit report right away. They sent her documentation showing she had done just that. JPMorgan sent her documentation saying, yep, we've got your dispute. So before I go into the further facts, I want to give you quick top tips if you face ID theft of any kind. And that can stem from, I get calls from clients that say, someone filed a tax refund for me. Yeah, that happened a lot. And you don't want to get into that. That's a horrible thing. All the way to my husband created an account and now has racked up a ton of stuff. And now I've got to deal with this because he put it in my name. I'd say 80 to 90% of all my ID theft cases are relatives. Anyway, ID theft requires extra work. Unfortunately, once you're a victim of ID theft, you have to do all the work. So document and save everything you do. If you must do all this work in defense of something you never did, document it. It will be your friend at the end of the road. But unfortunately, you're always on the defense when you are a victim of ID theft. File a police report. Judges, other attorneys, courts, credit bureaus will not take you seriously if you haven't filed a police report or some sort of FDCPA affidavit or investigation from whatever federal agency you use. That stuff's about to get weaker, but you've got to show you're not just saying it, you're documenting it. Remember, the basis of every ID theft protection, once you become a victim, is all about the documents, baby. Where have you heard that before? Use their documents against them is my defense to most lawsuits. Use documents of your own against them, because they're going to be coming back and treating you like someone that's making stuff up. It's just the way our world works. See all my videos on disputing debts, dealing with the FCRA, how to handle ID theft. Okay, so after dealing with JPMorgan for 2 years for this, my client receives a debt collection letter in the mail around September saying, you owe us the entire amount. Our client is JPMorgan. What are you going to do about it? And yeah, you have the right to dispute. So she did just that. She said, okay, I don't know why you don't know this, Stenger and Stenger, if you represent the company I've been dealing with for 2 years, but I am disputing this. Please validate your right to come after me. And what she was trying to do, I think, was to nudge Stenger and Stenger to paying a little extra attention, as they requested she asked them to do, so they could pick up the notes with JPMorgan and see she's been disputing it all along. But I want you to remember this: one hand does not know what the other hand is doing. You've heard that expression, the left hand doesn't know what the right hand is doing. In this case, that hurt her. They sent her a letter and did not know she had been disputing this whole thing all along. So turn that around. You know I've been doing videos on how to use securitization and when a creditor uses the mini Miranda in their lawsuit against them. So send a letter to JPMorgan asking for all the securitization information, send a creditor letter to JPMorgan, and send it to Stenger and Stenger, because you're going to get different responses. Well, you're setting yourself up and them. JPMorgan is going to feel they're regulated against filing stuff that isn't true. The SEC requires that a creditor detail not just to the SEC, but to its shareholders, all its securitization efforts. JPMorgan, Citibank, all those companies make a great deal of money securitizing the debt. If it feels like perhaps now they're coming after you when they don't even own the debt, that's true. Very insightful. So my securitization letter uses the left hand doesn't know what the right hand is doing against them. So my client sent a dispute letter to Stenger and Stenger and said, hey, get on top of this, man. I don't own most of the money. And she was nice. She revealed all her account statements and pointed out what she did owe versus the large majority of it, which was just weird countries, different countries. She wasn't traveling in any of these times. It was clearly ID theft. So they did the right thing and they said no. They sued her. Stenger and Stenger sued her, and for JPMorgan, in spite of all the stuff she'd done. So that day, she called up Stenger and Stenger and said, are you aware of all the work I've done investigating with credit bureaus and disputing, and that JPMorgan, your client, has been saying, rest assured, we're going to take care of this. They agreed. They admitted that she had done all that she said she did. Why is that significant? Let's find out. So here is the lawsuit, Shazam, and it's the 9 usual stuff that Stenger and Stenger does, 9 paragraphs. Let's focus in on paragraph 7, Shazam, and that says defendants failed to object to the accuracy of the billing sent to defendant or has otherwise assented to the balance and has failed, refused, or neglected to pay the balance. By JPMorgan, Stenger and Stenger, and everybody else's admission, she'd done exactly what she's supposed to do. And this is what happens with ID theft. It gets frustrating. So they lied when they said she's failed to object to the accuracy. Well, that's what I preach when you tear apart the lawsuit. Find the linchpin. Here's my linchpin videos, a couple of videos. All right. When you find the linchpin that is clearly wrong, unsupported, or in this case, completely false, that's your linchpin. But there's more. Go to number 8. Let's put up paragraph 8. The account has become stated between the parties. What does that mean? This is an account stated statute, lawsuit, meaning they don't have the contract. And if you notice in the lawsuit, let's put the lawsuit up there again, Shazam. There is nothing using the word debt, and all they can say is about an agreement is that it's in the possession of the defendant. So they don't have the proof of the contract they say she's violating, so they go to what's account stated. Most collection lawsuits are account stated statute lawsuits. So we have to look at the lawsuit again, and you'll notice the word debt is not used. Funny, aren't they debt collectors? Isn't she taking out a debt? What's this account for? Well, if you're disciples of my channel and my membership site, that's evidence number one that this debt has been securitized. JPMorgan securitizes most of its debt, especially credit cards. So you can look at all the references to the account as opposed to debt in the lawsuit. Let me put up a couple. Number 1, number 5, and again, number 8, defendant and or authorized user use the account. 8, the account has become stated. Number 1, defendant opened an account with JPMorgan. It actually is impossible to do that. You open up a debt, it becomes an account depending on if they originate and securitize or the way they treat it's a debt. Let's just leave it at that, okay? Why is there no reference to debt? Because JPMorgan does not own the debt. And in fact, if you looked at that lawsuit again, there's nothing in the 9 paragraphs that says they do. They don't say we own this debt. Interesting. They say we're chasing her for an account. Anyway, so an account stated statute claim is a replacement or a substitute for the contract they don't have to argue you breached. So in Florida, for example, a claimant must prove the following elements. Shazam, the balance is unpaid, there was an agreement to the amount stated, the parties had a history of transactions. Or in Michigan, they must prove an account stated claim. Shazam, mutual assent. Both parties must agree to the balance. Evidentiary admission. The parties admit the facts. New cause of action. The agreed statement replete. We don't care. The point in both of those definitions, which are basically account stated definitions throughout the nation, are there is no agreement. She clearly disputed and objected to this. The balance is unpaid. Sure. There was no agreement to the amount stated, whatever state you're in. And indeed, it's an ID theft situation, which they admit being aware of. So they don't have an account stated statute. That is your main linchpin. They don't have an account stated claim. They don't have a contract claim because it's not attached. That's your main linchpin. What sinks their ship further is the following mini Miranda. Shazam. This is a communication from a debt collector. We're attempting to collect a debt, and any information obtained will be used for that purpose. Sinks them, because Stenger's putting that on the lawsuit, and JPMorgan, let's call Stenger the left hand and JPMorgan the right hand. It's possible JPMorgan doesn't know Stenger's doing that, so that means they just made their client, JPMorgan, the only party on the case, a debt collector. Well, they are collecting for a third party. They're a servicer at best, servicing an account for a debt owned by JPMorgan Chase Trust. So send out your creditor and securitization letters to trip up the left and the right hand and use the documented response against them, right? Turn it on them. Why are you always on the defense? You didn't do anything wrong. So you've seen my linchpin videos. You've seen my account stated videos. I want you to remember the following tips in an account stated case. You ready? Let's put them up there. Shazam. Find the linchpin that's not true. And here it was number 7 and number 8. Keep everything documented when you talk to a plaintiff or its attorney or anybody. My client kept everything documented to her, and we attached it to the response, and it's clear she doesn't owe that debt. And it's clear they were aware she doesn't when, I shouldn't use the word, when they misrepresented in the lawsuit. Keep in mind, Stinger and Stinger pumps out thousands of these. They're not taking the care they should, especially in this case. We're going to do good for her. The right hand never knows what the left hand is saying, just like in life. Use it against them. Send out your securitization and validation letters. When they're claiming to be debt collectors on the lawsuit, all right, I need validation, JPMorgan. You just turned yourself into a debt collector, and you already are, and you know it. Plunk all of everything you've done into your counter affidavit, right? And send it to them in your answer and response and your affirmative defenses. Attached to this document will be, attached to this video will be a counter affidavit against JPMorgan, an answer against JPMorgan, a securitization letter to JPMorgan, a creditor validation to send to JPMorgan and the law firm, citing the mini Miranda, and my show notes, my wonderful show notes, which are directions to my editor, but they're also instructions to you as you go along with this video, or you just want to take, hey, did Parker say that? Ugh, I don't want to have to look at him again. I'll just go to his show notes. Anyway, now enough self-deprecation. I said the word securitization without fumbling and mumbling. And I very much appreciate you watching this new video on JPMorgan Chase. I wanted to do this because of the uniqueness of the ID theft. As I was studying, I'm like, this is just another ID theft / JPMorgan case that I can really get my teeth into and give you some good information. Even if you're not the victim of an ID theft, this will be a great video, as you know, with the linchpin. Always be looking for the linchpin. So, like, love, and subscribe. And remember our great membership website, collectionstoppersolutions.com. Go get them. Thank you.